whoever.
Chief Justice, Justices, you have an overview of SIPC's oral submissions in your condensed book at tab 1, and I would invite you to turn there if you wish to follow along during our brief oral arguments. However this Court decides the appeal today, SIPC offers a framework to allow the Court to interpret and apply reproduction rights in a way that Parliament intended, not as the parties have structured their licensing agreements, or as the appellant has argued its case, Justice Cromwell. Parliament has intended the reproduction right to be interpreted and applied in a purposively balanced, pragmatically efficient, and a technologically neutral way. SIPC's public interest framework for resolving this appeal aims to understand and not override Parliament's intent. The modern approach to statutory interpretation, which is well entrenched in the jurisprudence of this Court, does not ask the Court to make policy or imply exceptions or ignore Parliament. The public interest framework that SIPC submits as helpful in this appeal can show how Parliament drew the line between de minimis copies and compensable reproductions. I'd like to go to the end, to my last point, because, Justice Rothstein, I think this was the heart of your question. Where did Parliament draw the line between de minimis copies and compensable reproduction? SIPC submits that there are 3 criteria that turn a copy, in fact, into a reproduction under the Act. And those are that the copy must be multiplied, it must be durable, and it must be material. Multiplied, durable, and material. We know from the case of de Beer that copies which do not result in multiplication of the work are not within the inherently limited, purposively balanced scope of the reproduction right. This is not a case where anyone's seeking to relitigate de Beer. Multiplication is a necessary condition to engage the reproduction right. We know from the case of Bishop and Stevens and from ESA that durability or permanence is a condition of the reproduction right, a necessary condition. Chief Justice, as you wrote in Bishop and Stevens, and as you picked up on in ESA, Justice Abella, Justice Moldaver, a reproduction, a recording as you called it in Bishop and Stevens, is permanent. That's what makes it separate and distinct from a performance or a communication which, to use the words of this Court, is fleeting, transient, or impermanent. A reproduction has durability to it. The third criteria comes right from the language of the statute itself. When Parliament used the words material form, Parliament did not merely refer to the matter in which a work is embodied. It means the copy of the work must matter. It must be material.
But what section are you talking about there?
That's in Section 3 of the Act. It's embedded right in the definition of the structure of Section 3. And the inherently...
What words in Section 3?
In any material form. Material. Parliament's reference to materiality does not just mean the matter, the physical matter or digital matter in which the work is embodied. It means the copy matters. That's what distinguishes a de minimis copy from a material reproduction. That and its multiplication and its durability. Now, Parliament intended... I'm sorry.
Is there any authority for this proposition?
Yes, there is. And actually, I'll take you to the heart of that in point 3 of our overview of our oral arguments. There's ample authority for the proposition that Parliament inherently granted granted an inherently limited right to reproduce. Not all copies, in fact, are reproductions under the Act. The first and most important point is that the literal meaning of the word reproduce is not clear. If it were, this Court would not have split 4-3 in the de Beer case over precisely that issue. So there is ambiguity in the word reproduce, which requires the modern approach to statutory interpretation, purposive approach. Now, Parliament's overall purpose And the statutory scheme as a whole, as well as the practical implications, help this court understand why reproduction is inherently limited in the way I suggest, Justice Rothstein. Nobody disputes that Parliament intended to achieve balance. The only question is how it did so. Now, on one view, you'll hear that Parliament intended to achieve balance through the loophole approach. It enacted sections, Justice Cote, like you asked about Section 30.8 or 30.9, and that balance is in loopholes. But when Professor Weber said that users' rights are not just loopholes, that means users' rights are not just in loopholes. That is inherent in the statutory scheme this court has already taken. The view of the statutory scheme this court has already adopted. Parliament has spread balance throughout the entire Act. Take CCH and the Law Society of Upper Canada as an example, Justice Rothstein. Writing for a unanimous bench, Chief Justice, you wrote that the word original must be interpreted in a purposively balanced and a practically workable way, despite the fact that Parliament had turned its mind to very specific technical exceptions for libraries, archives, and museums. Balance is embedded in the threshold for copyright protection in the word original. More recently, in ESA, Justices Moldaver and Abella, you wrote that the communication right is inherently limited. Not all transmissions, in fact, are communications. Now, there are technical provisions defining what a communication is or is not in Section 2.41b, the provision this court relied on to hold that cached copies do not trigger liability of Internet service providers. But the court did not rely on those technical provisions elsewhere to interpret the word communicate in a purposive, pragmatic, and a technologically neutral way. Any other...
Can I just ask you, under your theory, where does Section 30.9 fit in?
SIPC's position on... That's an excellent question, and indeed, had it not been brought up earlier, I think that's the elephant in the room. SIPC's response to your question, Justice Cote, and your concerns, Justice Rothstein, are that we cannot rely on technological exceptions in one place in the Act, just like we can't rely on a contract from 1992 to interpret Parliament's inherently limited scope under Section 3. The existence of those provisions is equivocal, first of all, on the modern approach to statutory interpretation. Perhaps the answer to your question, Justice Rothstein, is that Parliament simply wanted to provide greater certainty in respect of these kinds of copies. The real problem with that approach is it's unsustainable. That approach, relying on the loopholes, requires Parliament to engage in a game of constant legislative catch-up to new technological change, which is inevitable and, more importantly, unpredictable. And so Parliament did not intend for itself to solve all of the problems through specific micro-exceptions or technical, the loophole approach. Rather, Parliament has embedded balance in every provision of the Act. To see how, allow me to turn to our fourth submission on technological neutrality. You see, Parliament has already future-proofed the Act in Section 3. It has empowered, indeed it's entrusted the courts to apply a technologically neutral approach to Section 3 of the Act. Now, the merely formalistic view of technological neutrality that you may hear about is inadequate. And the reason it's inadequate is because merely protecting authors' rights alone in new media, the so-called media neutrality approach, would actually upset Parliament's balance every time technology evolves. That's why this court, in numerous cases, from Robertson to Rogers, has held that at least technological neutrality means non-discrimination between business models that achieve the same effect.
30.9 just deals with broadcasting. It doesn't deal with a particular technology, digital or analog or anything else.
Precisely the point. It's impossible for Parliament to deal with every technology like that. And so the public interest framework understands that Parliament has already embedded balance in Section 3, irrespective of the technological exemptions, or in addition to. That is how this court has applied technological neutrality as a way of future-proofing the Act, so that legislative amendments are not necessary every time there's an unpredictable new technological innovation. And that's how we protect the public interest. Incidentally, this approach is perfectly consistent with international law. It's not credible to claim that Canada would be in violation of its international treaty obligations, which may be another indicia of Parliament's intent. Everyone agrees the job is for Parliament to ensure compliance with international law. The difference of opinion is in how it did so, whether it did so in those technical loopholes or rather whether it did so in Section 3. And that is how this court can apply a framework in a way that compensates authors fairly for multiple durable and material copies, not every time another party realizes value from technological innovation. May I answer any other questions for the bench? Thank you.
The court will take its morning recess. La cour prend la pause matinale.